Hello, everyone. My name is Maria and Angelescu, real estate agent with the mother-daughter team based here in Burlington. I am joined by a lovely, lovely close time relation of mine and friend, Angie Smith. We are going to be talking a little bit today about landlord and tenant relations. And we know that things have gone in many different directions, especially since the pandemic. Things have changed a lot, and landlords and tenants, some are getting away with certain things, others just don't really know the rules. So we're really just here to debunk and really talk about what governs landlords and tenants at its core, some misconceptions, and just some common questions that people have when they're getting into a rental or they're a landlord and they're leasing out their property. So without further ado, I will pass the floor over to Angie to introduce herself, and we'll get right into it.
So my name is Angie Smith, or Angela Smith. I'm with the office of Caveat LLP. I'm one of the partners here. We have 3 partners at this office and 2 lovely staff. We are a full service law firm that deals with a lot of landlord and tenant matters, but also small claims court and other tribunals. But we focus on landlord and tenant. So in a brief nutshell, that's us.
That's awesome. So let's talk about the Residential Tenancies Act in general, because we want to make sure that we're not confusing who this act applies to and who it doesn't. So who does this act apply to, Angie, and who does it not apply to?
So broad strokes, landlord and tenants. Having said that, it's particular in its view. When you look at the definition of what a landlord is, it's broad strokes, right? For a long time, property management companies could actually be named as landlords. They can't anymore. A divisional court decision came down saying that they couldn't be, but it governs things like solo landlords or corporate landlords. We're not really looking at student landlords, or let's say if you live with your landlord. So if your landlord lives with you, the act will not apply to you. It does govern things like mobile home parks, but in specificity in certain situations, things like that. But you have to be really particular and careful when you're dealing with student housing and things of those natures. Get someone that knows what they're talking about with respect to that. The act is very particular and it can be finicky. So I would say in a nutshell, that's really what it deals with.
Absolutely. So that's great. And so then talking a little bit more about the act, do you think it does a good job of protecting landlords, tenants? Do you find that it favors one more over the other? What are your thoughts on that?
So okay. I always, when talking to my landlord clients, I always explain to them, if it feels unfair, it's because it is. The Residential Tenancies Act was born from an act called the Tenant Protection Act. It's way back in the day. It was there for tenants to protect them against scrupulous or unfavorable landlords that practiced unfairly against tenants. So when you look at the Residential Tenancies Act, it was born from that act. 80% of the Residential Tenancies Act is for landlords. Is for tenants, my apologies, and not for landlords. So 20% of that is in fact for landlords. It's a very small bit. There's 4 sections that are actually there for the landlord, not for the tenant. So really, when we see the act, it favors the tenant. It protects the tenant. And then we have 4 sections that actually help with a landlord in terms of how they bring an application or their obligations underneath the act particularly. So we have to be really particular and careful when we're looking at landlords. There's a lot of obligations, a lot of things that landlords need to follow, and then there's wide berth for tenants and protections for them.
Absolutely. So that kind of segues right into my next question, which is great, where because we see that landlords don't really have that many rights, protections against them under the RTA, we're finding that they're trying to find loopholes or maybe, take advantage of tenants who aren't familiar with the RTA, although the internet has changed that, right? Decades ago or even years ago, people didn't really have access to resources in regards to the RTA. And so we find that a lot of things were slipping and sliding and landlords were pushing things onto their tenants. But now tenants have access to these resources online where they can actually tell their landlord, according to this section in the RTA, you are actually not I am actually not required to do these certain things. So what are some responsibilities or obligations that you see most often landlords are pushing onto their tenants that actually the tenant should not be doing?
So it really, one of the big ones is water heater rentals. A big one a lot of landlords try to put in there is water heater rental. You have to pay for it, you're using it. Well, no, it's a rental. The landlord gets the benefit at the end of the day for that water heater rental. They get to keep it. So that's one thing. Another thing is maintenance obligations. So let's talk about snow removal, things like that. So there is some new case law that's come down with respect to this, whether it's a multi-unit or if it's single use. So if it's a single use residential, you're going to be responsible for things like maintenance. But if there's an upper and lower level, which we see a lot of nowadays, I'm sure you see this quite often, upper and lower, yeah, because we're trying to get as much money out of our property that we can, the landlord is actually obligated to take care of the maintenance. So if they can do this one of two ways, they can either rebate the rent, they can give them a rebate from the rent, or they can actually hire someone to do the maintenance at the property. And we can go into that for days and days and days in terms of that. Another thing that in terms of obligations with respect to the property is general upkeep of the property. So if something's happening at the property, make sure you reach out to the landlord to tell them that something is wrong with the property. You shouldn't be changing the filter at the property. You shouldn't be buying new appliances. If someone tells you, no, it's your responsibility, it's not. You need to reach out to your landlord. Another one is lawn maintenance. So in terms of upkeep of the property, if you are being asked to cut the lawn and you are in a single use residential complex, then of course you are going to be cutting the grass, but the landlord has to supply the lawnmower. So things of that regard, and like salt and whatnot.
Absolutely. And what I find as a real estate agent and on that side of things is that we know that these things aren't allowed, and our tenants know and are educated saying, I don't have to pay the hot water tank rental. I don't have to mow the lawn because I'm in a 4-unit, house or whatever it is. But then we get issues or pushback when we're submitting an application from landlords saying, well, actually, I'll just wait for another tenant to come along that is going to do those things. So even though we know that, the landlord actually should be taking care of these responsibilities and obligations, it becomes very difficult for our tenants to get into those units if they, if they have any sort of pushback saying, oh, no, well, I'm not going to pay your hot water tank rental. Then the landlord says, okay, then we're not going to sign a lease. So that becomes a little bit difficult. And so I'd like to talk a little bit more about these kind of disputes. So what are more common disputes that you're seeing, during hearings between landlords and tenants?
The big one right now is non-payment of rent. Unfortunately, that has skyrocketed. As we all know, cost of living, everything has increased. So we see a big strain on society as a whole for landlords and for tenants. So the big one right now that's happening is the non-payment of rent sector. They were putting a lot of emphasis on getting resolution with respect to non-payment of rent. Having said that, we're not near where we should be. Before we get to a hearing, we're seeing 5, 6, 7 months. And at that point, we have 8, 9, 10 months of unpaid rental amounts, right? So that's a big one. Another one we're seeing that is actually getting a lot of priority is agreement of purchase and sale. So when you have a tenanted property and you have a deal going down, they're coming out very quickly. Within 2-3 months, we're seeing a very quick turnover time with respect to that. But we're seeing a lot of non-payment of rent, a lot of persistent late payment of rent, and a lot of bad faith applications. So we're seeing a lot of applications with respect to bad faith, where someone's given a notice in bad faith, where they've given an N12 or an N13. So for whether it's purchaser or personal use, and also for renovations, right? So we see a lot of those, and we see a lot of help from the government coming down through the Tenant Defense Fund, which a lot of tenants don't know exists. It gives them access to money to bring an application. So they get up to, I believe it's now $1,300 to $1,500 assistance that they can pay a legal representative to bring a tenant application for them if they feel like it's been in bad faith. But we could talk for hours and hours about those and the technical requirements for those.
Absolutely. So then that kind of segues into rent evictions. I feel I have clients that have dealt with a bunch of rent evictions where landlord says, you know what, I need to do some big repairs to the property. So here's an eviction. You're going to move back in a number of months when the renovations are done. Then they never hear from the landlord ever again. You see it go back on MLS or on Facebook or on Kijiji, and they've created a whole new unit, or they're just renting it for a higher price. So what recourse do tenants have when those things happen? And is there any recourse?
So there is. So in N13s, when you give an N13, it's one of the most technical applications that are out there. So for the landlord side, I would say you need to speak to a legal representative. There are certain applications that I would say a landlord can actually probably do. I mean, even the L1 applications for non-payment of rent are becoming highly technical and improbable or inconsistent. But having said that, if you are doing N13s, there are obligations that a landlord has that are requirements for, your N13 and giving a tenant a notice to end their tenancy. One of those obligations is if the tenant actually leaves, you have to notify that the tenant that the renovations have been completed. But a tenant's obligation is giving their right of first refusal. So that's important. So just like I'm saying, a landlord should contact a legal representative, so should a tenant. A tenant has obligations and requirements as well. So did you let your landlord know where you were going to be, how they could get in contact with you? If you didn't do that, then how are they supposed to get in contact with you? So unfortunately, at that point, there falls your application for bad faith. Having said that, if you've done all of those things and you followed those obligations and you find that a landlord has just re-rented the unit for a higher rent, then you can bring an application for bad faith to the Landlord and Tenant Board. You may be waiting some time unless you're homeless. Now, if you are homeless as a result of these renovations, you can get a request to shorten time. So that's something that can be heard. An interim order can be issued for you to be put back in the property or to halt the landlord from actually re-renting the property. That's a big piece. But I think there is recourse and it's massive. We're seeing a lot of decisions come down from the Landlord and Tenant Board about the damages that a tenant has access to because of a rent eviction, so to speak. And rent eviction is not actually a legal term, right? It's this global term that's been cast onto people that have been, displaced from their home based on renovations. But having said that, these are your vast damages. So we're talking about the last rental rate for a period of 12 months. How much is that? We're way up in the $20,000-$30,000 range, right? Moving costs, things of that nature. And we're actually looking at decisions where they look at the mental anguish that has been caused as a result of the tenant being displaced. I actually have a client right now that was displaced as a result of one of these, and it, has been staying in shelter to shelter. So from there, you seek general damages or compensation for mental anguish. But I would say this is something that's going away in terms of landlords actually seeking for renovations, or this rent eviction is actually starting to dissipate just because of the ramifications, especially for corporate landlords. We're seeing a lot of damages, even fines to the board that we weren't seeing, massive fines to the board. So yes, is there recourse? Absolutely. Yeah.
And sounds like recourse wise on the tenant side of things could be pretty intense.
Yes.
And so like you're saying, the chances of rent evictions happening these days are a little bit lower, or the cases of them happening because of the recourse that the tenants have. So that's good to hear in a sense, because I can't even imagine how, like you said, displacing someone, they don't have a home, they're your client that's going from shelter to shelter. That's insane. And so that's why we have the RTA in place to protect these individuals. Obviously, landlords want to protect their investment as well. There's a lot, they have to put 20% down payment of the purchase price to be able to even get that property. So then when they have someone that's either not paying rent or they've trashed the property, maybe that's when we start to see the pressure come on and we see them start to do things that they shouldn't be doing in order to protect their investment. So I understand the hardship that some landlords are going through as well, but we still have to, act with integrity, act with transparency and honesty, because I think at the end of the day, that's going to get you the best result possible, both on the tenant and the landlord side of things. So I'm glad that you touched on that. Going back to the technical side of things, when you're filling out these forms, how important is it when filling out documentation? Because I heard, can't remember who I heard it from, but even if you get, let's say, the postal code wrong, or the tenant's name is spelled incorrectly, that would make that document invalid. So how important is documentation in these cases?
Right. So an application, just as you've said, you've hit the nail on the head. Unfortunately, your notice cannot be amended. So an application, that's you're applying. So your notice is your triggering document. So that's what you're giving to the tenant to put them on notice. It's called a notice to put them on notice that you're doing something, whatever it may be, an obligation to pay rent, to stop doing something, or to say that renovations are going to start. If something is defective, and that's what it's called, it's a defective notice, then unfortunately the application can be thrown out on a whim. And I've actually had 2 of these kicked in the last week in terms of preliminary issues. You know, a lot of people don't realize if you don't do the termination date on the last rental date, excuse me, which let's say you pay rent on the 1st, is it the 30th or the 31st? So the termination date has to be on that date. If it's not, the application will be dismissed. Another big one that people miss is the compensation, right? So it's a legislative requirement to pay compensation when you give certain notices. And a lot of landlords say to me, well, why am I giving compensation? Well, you're giving compensation because you're asking someone to leave the property. It's assistance for the tenant to move, right? So then we get into this cash for keys thing. Let's, what does that look like? But having said that, that compensation has to be given before the termination date on the notice. There's another defective nature of an application, but just on the notice alone, again, yes, if the postal code is wrong, if the address is wrong, if you have an upper and lower, despite it being legal non-conforming, whatever it is, you have to designate. If you have an upper and lower tenant and you don't designate upper and lower, unfortunately, your notice will be kicked out. Why? Why does that happen? Well, we have an enforcement officer that comes to the property. Let's say you get an eviction and you don't have upper versus lower. The sheriff will sweep the property. Everyone will leave. So now you've removed both tenants when you only meant to remove one, right? So that protection is there for that reason. So yes, if one letter is wrong in your postal code, if you don't do upper or lower, or let's say you're even missing a landlord. So people also don't realize that, and a notice can be deemed defective because you haven't listed all of the landlords on your notice. So and that just goes to the heart of the RTA under section 43 subsection 1. So that's just making sure that everyone knows what's going on. What's this document? Who's it pertaining to? And what do I have to do as a result of it? So yes, I would say without fail, even if you don't want to pay for a legal professional, get them to review your documentation, right?
Absolutely.
So that's what I would say.
So then speaking to, because that was one of a follow-up that I had then is, when is it a good time to hire a paralegal? Is it right when you're giving those notices? Is it before that to see if you even have any recourse, either as a landlord or a tenant? When do you think a paralegal or a legal representative in general should get involved?
So I would say from the moment that you think something's wrong or you would like to do something. A lot of my colleagues, a lot of people out there will give you 30-minute free consultations. That will be invaluable to you, right? So within that 30 minutes, you may not get the secret sauce of the paralegal or the legal representative, but they will get you on the right track, right? So I would say from that moment, and let me tell you, I've talked to many people that told me, oh, well, I'm just going to do it myself. And they wind up calling back anyways, because something happened along the way that they didn't realize. So whether it be a landlord or a tenant. So I think it's really important, as you said, you need a legal professional, whether you think you can do it or not, have them look into your case as a whole. What's the best avenue, right? So I think that's really important, even at the beginning. When you think that you're going to do something, call someone, right? There's so many resources available. And as I said, with a 30-minute free consultation, our office does it. I know a lot of our other colleagues do it. So just call someone and ask them, because like I said, like you've been talking about, these slight little errors, right, can cause you your whole application after waiting and waiting and waiting to hear the case before the board. So
yeah, right. Like you said, documentation not filled out correctly, that can be absolutely detrimental. So the point is, they should have called you right in the very beginning rather than doing it themselves. Maybe there were some mistakes and they've just wasted 2, 3, 4, however many months because their application has been thrown away, right? So it's better, like you said, just get someone involved as soon as possible. Take their advice. That's why these professionals exist, to help you make sure that you're doing the best thing for you, right? So then let's talk about the hearing, I guess, timelines right now, because like you said in the very beginning of our call, we're looking at 5, 6, 7+ months of getting a hearing. Do you foresee that getting any worse or getting any better? Are there any efforts that are being made to ensure that your hearings are happening faster and we don't have these super long wait times?
Uh, that is, yeah, we could probably have a whole discussion about that. Honestly, just about that. So before we were seeing 7 to 8 months to get a hearing date. So we're still seeing that in certain circumstances. Before we were seeing even longer than that, which was crazy to me. They prioritized your non-payment of rent because they saw a lot of solo landlords that were out there being hit hard, right? So they can't uphold, and people were losing their houses before they could even get before the board. So with non-payment of rent, we're seeing about 5-6 months. We're seeing, again, like I said, a priority push to purchasers or personal use. A lot of the requests to shorten times are being, turned around. I actually just, I submitted an application and we have a hearing date for July 11th. Now, is that the rule? No, that's the exception. Having said that, they are putting priority into purchaser and personal use, but we're seeing approximately still 6 to 8 months before a hearing time that's happening. So, that's why we're saying do it sooner rather than later. If something's happening, get it done, because you're not going to be heard tomorrow. So you have to plan for the future. So is anything happening? I mean, we won't get into politics, but I think it all stems back to, what's going on in the world and what's needed. And I think all of the landlords, everyone needs to band together. And what we're seeing is this big divide between landlords and tenants. And I'm one of those people that thinks, listen, we all have something to lose here, whether it's a landlord with their income property and a tenant with somewhere to live, right? So we understand someone has a commodity, something we want. We have money where we can stay, right? It's housing that's available to the general public. Let's work together to make it work. Instead of this opposition, let's find a happy medium where we can come together. And I probably, people are going to scream at the screen. I understand. It's a bad climate right now out there, right? So it's hard for people to pay their rent. It's hard for landlords to stay afloat. But if we don't work together, we're not going to find some way to move forward. So, I mean, I have my own thoughts and views of how we can make the system better. Having said that, you really need to find a way, given the fact that there's such wait times, to work with each other, right? There's an obligation when you bring an application for non-payment of rent to try repayment arrangements. And some people bury their head in the sand. Sometimes it works. Sometimes tenants just get very scared and they stick their head in the sand and they don't know what to do. I'm going to tell you, if your landlord serves you an N4 for non-payment of rent, don't stick your head in the sand. Even if you give them something, it will help, right? The landlord will try and help with you, work with you, and you will get to stay in your place and will not be evicted. So, I mean, with the wait times right now and how things are happening, try and work together. That would be my solution in this.
Absolutely. And so do you always see that disputes have to be solved at the Landlord and Tenant Board, or are there other avenues that people can go down when it comes to solving disputes?
So you can, and this is a new function of the LTB, relatively new, where you can speak to a dispute resolution officer where you've come to an agreement. And I'm trying to explain to everyone, it's always better when you have the power in your own hands, right?
Yes.
When you're not letting an adjudicator decide on that day. And it may not be your best day. Maybe you're nervous, you don't know what's going on, and you're just, you're nervous and whatnot. So, it's always better for you to do what you can to work before to get the resolution that you're wanting. So let's say you and your landlord come to an agreement, and you can then go on and you can say agreement's been reached, and you can go with the dispute resolution officer that will put something into an order far before your hearing time. That works for the landlord as well as you. Now, the landlord may want some assurances. It's called a Section 78. It's very well known, a penny in a day clause, or even with respect to behavior. Let's say behavior is happening and you don't want the behavior to continue. The tenant goes, oh, I absolutely won't. Okay, perfect. So you can enter into that. That's one of the tools that are available. I always say it's better to have power, right? When it comes down to it, you both have come to an agreement that you agree to, and you both adhere to that agreement. So that's one resolution tool that can actually speed up the landlord's process time and can give some power back to the tenant. In terms of that, how many applications that I deal with go to the Landlord and Tenant Board. I would say 90% of them, sadly.
Right.
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 So despite me calling and just the way that I'm talking to you, I would be talking to a tenant or to a landlord to try and resolve the matter. But sometimes we're just too far apart. We either have
Right.
someone who's principled or who's just too tired, right? They've tried and they can't get the resolution. So, I mean, I would say 90% right now are sitting at a hearing before the LTB.
Right.
But
And that brings it back to hire a paralegal or speak and have that consultation with the paralegal right when you think something is happening or you want to do something in the future, because then it's going to save costs on both ends, both the landlord and the tenant, a headache. And that could be the best recourse if you get on top of things early enough rather than waiting for it to drag on, where it has to be taken to the board, right? Because then that will take pressure off the board as well, too, right? So it's really just putting in some preventative measures or more proactive measures so that people can come to an agreement and, like you said, put the power back into both parties' hands rather than letting a third party decide their fate, right? And how much they're going to have to pay up front or what the recourse is going to end up being. So we're going to backpedal a little bit in terms of actually getting into a lease and signing into a lease.
Sure.
What are some red flags that you see on the landlord side of things that should really tick off tenants to think twice before signing an agreement?
So when a landlord asks for an exorbitant deposit, so that's a big one. Let's say a landlord says, you have to supply me 6 months up front. That's absolutely illegal. It's unlawful. They can't ask for that. It can't be in a requirement. Let's say that they've put an ad out, and this is contrary to the human rights code, to say, I only take professionals, right? So I only take single professionals. Well, they can't ask for that as well. If you have someone who's requesting so much documentation, right? So you've supplied the standard, a credit check, an employment letter, all of these things, but they still want more and more and more, or they want to meet you, or they want to have so many people involved, which is why I think it's important to have, a realtor or someone involved in the process that can guide you along those steps, right? Such as yourself, who can look through a document and say, whoa, what is this doing here, right? Or, having said that, on the flip side, a landlord making sure that the tenant has tenant insurance. It's something that, every time I have a landlord call me, they say, well, they don't have tenant insurance. Well, did you get a copy of the tenant insurance before you handed them the keys? Well, no. Okay. Well, then you should have gotten that, right? So it's really important, these things. Credit checks are a must, employment letters. And this is the thing, you may have a tenant who has great income but bad credit, or, great credit but bad income. These are all things that you need to look at as a landlord with a commodity that says, okay, I'm going to deal with this. This is my business venture, and stop looking at it as people. And unfortunately, I hate to say that, but this is a business, right? So look at it as a business would. What makes sense to you? So make sure that you have those things. So you can't ask for 6 months up front. Look for a landlord that's asking for 6 months up front, or it's exorbitant over the top. But I would say those are the things, big red flags in terms of exorbitant deposits or damage deposits, things like this, exorbitant deposit amounts or key deposits or whatnot. You can ask for a key deposit, but not something insane unless you have like a golden fob, let's say, right? Like it's like
Exactly,
$500. Yeah.
Exactly. It's made by Louis Vuitton.
Yeah.
And all that. Yeah. So, and going back to, okay, we can't ask for key deposits, but let's say a cleaning deposit. I've seen people ask for that. I've seen people ask for deposits because they have pets. And speaking to pets, because this one is very near and dear to me, and especially because so many people, especially during the pandemic, have a furry or got a furry friend, whether a dog or a cat, whatever it is. And we're seeing so many units come up that say no pets allowed. When is this illegal? When is this clause void in an agreement?
Always. So let's just say that the RTA actually spelled this out, and what they were finding is a lot of individuals were being denied because of pets, right? Mm-hmm. So landlords were very scared about their properties being destroyed because of pets, and I understand that, right? You want a tenant that is going to make sure that they pick up after their pet. Their pet's not going to chew everything. Having said that, you cannot discriminate someone based on their pets. So what we see now is tenants just lying about the pets, because unfortunately, if you find out that they have a pet, you can't remove them. It's not possible. So get into the mindset of the love of the furry friends.
Yes.
Right?
Yes. I love that, actually.
I mean, when it comes down to it, if you're an animal if you're an animal owner of any kind, whether it's dog, pet, guinea pig, whatever it may be, you're going to take care of those animals and understand as a tenant, if you have a pet, keep up after your pet. Pick up after your pet, right? So don't leave them home alone for 16 hours where they're chewing and gnawing on things. I mean, I find that inhumane anyways, but I realize people have to work. So when it comes down to it, you can't ever say that pets aren't allowed. It's just not, there is something in the RTA called a non-pet provision void, meaning you can't ever put a no pet provision in your agreement. So you can't ever say no.
So basically, yes, to all of our furry friends
Yeah.
who have them, don't stress. But obviously, we have to kind of get landlords on the same page as well to say, look, 9 out of 10 people that I work with, they have some form of pet that is coming with them, right? So let's try and get on board with that. Obviously, we want to look at the tenant as a whole. And so if you have an amazing tenant on paper or in person, and you're going to say no to them simply because they have the pet, chances are you're going to come across that many, many, many times with the many applications that you get, or you're going to get someone that's lying straight up to you. So just try and open, your viewpoint in regards to that. And this has been a fantastic conversation so far. I'm going to just ask you one last question. And I know that you were speaking about, some change that you'd like to see in the RTA or just, landlord and tenant board process in general. So what are some changes that you think are necessary or you'd like to see in future for the RTA?
Okay, so here's my big idea, and I've talked to anyone who will listen about this, an accelerated process with non-payment of rent. I mean, I don't think for multiple reasons. One, the application could be flagged in the very beginning as defective. Why are we wasting the board's time of sitting there and adjourning out matters when we could be handling it ahead of time? This could be done in a case management hearing. So my suggestion, just on the simple basis, is if we have a tenant who's not paying rent, or if the tenant isn't paying rent, we can set, within 6 to 12 weeks, a case management hearing to talk about a payment arrangement. I mean, it's an obligation of the landlord to reach out to the tenant anyways. We could have a dispute resolution officer that's available to try and facilitate a payment arrangement. And then we are freeing up a lot of the board's times. I would love to see a lot more of case management hearings, case conferences that are allowing people to have open and frank discussions that allow the adjudicator to say the strengths and weaknesses of each case just on a frank, neutral, third-party basis. And it will flush out the system to allow adjudicators to actually look at meritorious applications, something that actually should be before the board. Maybe it's a novel idea, a question of law that really should be decided. Or maybe it's someone who hasn't paid rent for 12 plus months and we're now getting to this point, or hopefully we don't ever get to that point, but it will actually free up the board's times to have that. Another very quick and simple is if you have something, and this is for my friends, my legal colleagues, but if you're withdrawing a matter, don't wait for the day of to show up and withdraw the matter. We have forms now that we can submit ahead of time. So maybe landlords or tenants don't know this, but you can actually withdraw an application before you get to the board if you don't want it to be heard. So use those simple, tricks. If you're not going to go forward, don't wait for the day of, right? Or reach out to the other party to see if you can come to some resolution. If you go with the consent, you can actually go before the adjudicator. One of the first things that the adjudicators will hear consents or uncontested matters. So if you have a consent and you've reached that consent, you won't sit there all day, right? So try and reach out, and remember, we're all people in this. So where can we sit where we're both equally unhappy? And I know everyone wants all. And I recently had a judge say this, and he thinks of this in terms of Venn diagrams. So we have two parties sitting here in these big bubbles and they want everything. And then somewhere they intersect, right? And that's where people are equally unhappy. So I think that's where we both have to come up with, okay, I'm in a non-payment of rent situation as a landlord. I want my rent, but maybe you're not going to get it all right now. Right. And remember, even if you go to the board and you get an order saying that you're going to get the money back, are you ever actually going to see it? Right. So you have to garnish. So there's further legal costs, further filing, et cetera, et cetera. So if you can actually get a tenant who was a good tenant, who's just fell off a little bit or come across hard times, you can get that money back and get back on track within 12 months. That's what you're likely to get from an adjudicator anyways. So let's all talk before we get to the board. So those would be tips and tricks on my thought, but
And those sound like very, very good ideas. I hope that one day these things will be implemented soon, and to just take some pressure off of the Landlord and Tenant Board, get those hearings happening faster. Or at the end of the day, like you said, be proactive. Let's try and not take so many issues to the board if they can be resolved prior to. So basically, at the end of the day, proactive, do the proper documentation, and try and mediate before even getting to that point. So what are some, just kind of wrapping up, what's a really good resource or website that you'd like to send either landlords or tenants to just find out more about their rights or next steps?
So interestingly enough, if you go to the Landlord and Tenant Board, beside each and every form, there's instructions. So it won't be fulsome, it won't be on, to the T, but it will tell you instructions on how to fill out the forms or how to fill out the applications. Another great one for landlords is the Landlord Self-Help Center, and then another one for tenants is your local legal clinic. They will always assist, right? So if you go there, you can ask them some questions, or like I said, call and get a free 30-minute consultation, right? So you could always reach out to a legal professional. And my suggestion is go to the reviews. What do the reviews say about your legal professional? Now, you're likely not to have someone who has 5 stars and perfect reviews, but if the majority of them, or 90+% of those reviews, say that they helped in this and that or whatnot, you can call them, and you're not bound to just one legal professional. You can call and get 1 or 2 resources or whatnot, and see what they say in the consultation. Having said that, who do you feel comfortable with? Every representative isn't for everyone, just like every agent isn't for everyone, right?
Exactly.
So, but I would say those are my top, which is go just reference the instructions for the notices or the applications. And then there's the Landlord oh my goodness, the Landlord Self-Help Center. And there's also there's a tenant advocacy group, a whole bunch of great work as well.
That's perfect. So we have a bunch of resources that we can look at. I mean, this whole video itself is going to be a huge resource for landlords and tenants out there. So I just want to thank you so much, Angie, for taking the time to do this. I'm going to include all of Angie's information and my information in the caption. If you want to reach out to us with any questions, if you have a dispute or some form of issue that you want resolved and you want to just get on that 30-minute call to do a consultation with Angie or one of her colleagues, absolutely, I implore you to do so. You're going to find out a lot, and you're going to find out what your best next steps are. So make sure you take advantage of that. I want to thank you, Angie, again, and I hope everyone has a lovely, lovely day. Thanks again.
Thank you so much.